Hi, everyone. Thank you for joining our first Golden Resources webinar. I wanted to thank and introduce our speaker tonight, Michael Korsinsky. He is a founding partner at Korsinsky and Klein, and he dedicates much of his time to elder law and health law matters, as well as being the appointed counsel for Chaim Aruchim. And we thank you for giving us your time tonight. He navigates very tough questions that come up, and we're happy to have him here tonight.
Thank you very much. Good evening, everyone. As you just heard, I'm a founding partner of the law firm of Korsinsky and Klein, with offices in New Jersey and New York. Tonight, we're going to be discussing the very brief, at least some of the topics of the financial, legal, and halachic issues for seniors and their children. Just to kind of give you a little background, many people, I'm going to actually share my screen as well so you can see some of my material. Let me do that in a moment.
Oh, Mindy Litsky's on. That's interesting. Can I have a...
Okay, I hope you can see the screen. As I was mentioning, my firm does trust and estates, and we're involved in all aspects between, planning documents as well as litigation and even for hearings and guardianship. So we have a vast knowledge between our 10 attorneys here and our staff of the various different issues that come up and different matters. I'll begin with a story that we had where people came into our office. A woman, she has 2 daughters. She's elderly. She comes into our office to do estate planning. She says, I get along with my children. Everything is great. I just need you to help us with the financials. Make sure everything's in order. I believe she wanted Medicaid planning, if I remember correctly. And we come in, we have the intake, we speak to her. And then she says, don't worry, my 2 daughters get along with everything. No issues, just make everything equal. And I mentioned to her that we need, one of the documents we recommend is a healthcare proxy or health directive, who to make decisions for if there's a healthcare issue that comes up and you're unable to handle the affair, who should do it, which daughter? Because in New York, you need to only one could do it initially, and you can have a substitute. So she says, no, don't worry, I don't need it, everything's perfect. And we continue our conversation. And one way, it's a simple document. It's not that very complicated. And I say, okay, fine. We continue our conversation. Then I say, by the way, I ask her, what's your position on the COVID shot? And she, right away, when I said that, there were 3 people in the room, her 2 daughters and her. One said, for sure, give it. The other one said, no way am I giving it. And she said what her opinion was, which was not to give it. She heard right then and there, she like froze. She's like, right then and there, she realized, hold on one second. There are issues where I need to really think about this, because she had 2 daughters who get along, who want the best for her. There's no question they both care for her mother fully. They want everything that's perfect for her, but they have different views on how to handle making healthcare decisions. And then she realized, she said, I'm not leaving here today unless I have a healthcare signed. And in fact, she didn't even want to wait because the other document's more complicated, come back a different day. She didn't want to leave our office unless she had, in this particular case, she wanted the Chaim Aruchim form that we had. And the Chaim Aruchim form specifically allows, and I can tell you where to look at it. It's going to be on my screen in a moment. The Chaim Aruchim form, if you'll see, you can go to their website. It's chaimaruchim.com. On the right side, you'll see something called medical directives. And there are medical directive forms or healthcare proxy forms, depending on what state you're in. They're there. They're free. There's no charge. You can use that form. Many states have their own form as well that you can find. Hospitals many times want people before surgeries or procedures to have their standard form. So, you know, it's an important form. People don't really think about it, but if they really step back, I know Chaim Ruchim advocates very much that people sign the form. There's the form that they have on their website. They have 38 states, different forms for 38 states, for the District of Columbia, and 2 Canadian provinces. So that's the form. Those are the forms that they have available. Our firm doesn't use quite that kind of form, but we use a similar type of form depending on the specific circumstances. But it's important that you recognize that this simple form, which you can spend time in advance to think about it and how you want your healthcare decisions to be addressed down the line, should you, God forbid, become in a position that you're unable to make your own decisions, this form is a good form to have, whether it's the Chaim Ruchim form, whether it's the standard state forms, or a more complicated form from an attorney. So this is something that I want to kind of bring to your attention, which brings me to the general aspect on the financial aspect of estate planning. So regarding the succession plan, there's something called succession planning, estate planning, and planning for wills and trusts. So again, I'm going to give a kind of a very brief overview of what these items are, because people have heard about wills, people have heard about trusts, but they don't know what they are, how they fit in with an estate plan. And really, everyone's plans really depends on their specific circumstances. One person, you know, people will come in and say, at this community center, I know they have a trust or they have a will. I want the same thing like them. Doesn't always work. You really need to, every situation, and we'll get into some of the circumstances that need to be considered that are unique for each person and each family circumstance. So those are things that people should think about. So we're going to talk about succession planning, estate tax planning, and planning with wills and trusts. So what is succession planning? Succession planning means ensuring that your assets pass in the manner that you intend upon your death. So people have assets. Some people have more, some people have less, but it's something that they worked really hard to get those assets, and they would like to make sure that they pass in the manner that they wish for it to go. One area that I've had issues, for example, even if, again, nobody's fighting, everybody's getting along, but for example, if there's a special needs child, and if you don't do appropriate planning, that special needs child is going to automatically, as a matter of law, get some assets. So if someone has 4 children, has $1 million, and one child is on government benefits, that one child is going to get $250,000, get thrown off government benefits because appropriate planning wasn't done. So again, no one's fighting, everyone's getting along, but the government is going to come in and make problems. So it's very important that people understand these issues. So there are 3 ways, and I have this on the screen if you can see it. There are 3 ways that assets can pass upon someone's death. There's something called by operation of law, which is automatically, through a trust, or through the last will and testament. Operation of law is what we in law school know it as the poor man's will. You can put accounts with beneficiaries on it, joint accounts with rights of survivorship, or in trust for accounts. If you have any of these type of accounts, then upon death, these assets will automatically pass to the named beneficiary or to the joint owners. So again, you can have joint accounts, and those accounts automatically go to the person that is named as a beneficiary or a joint owner. Last will and testament, this is the kind of thing that people have heard. Yeah, I want a will, I want a will. This is what a will is. A will is a document that's actually filed in court that directs how the assets should be distributed upon death. Who gets it, how they get it, any terms and conditions, all that would be in a last will and testament. Now, the will not control assets held in trust or joint accounts, so won't control it whatsoever in most circumstances, unless the trust specifically says that the will should control it. And a will can include other instructions that require decisions after death, the appointment of an executor, who should be in charge, guardians for minor children, directions for funeral burial. That could all be done. I will warn one item: for those who under the under Orthodox religion, they may not have the will, so you can't, they if they want to do an immediate burial, that's not where you should have the directions. A will must be, now there's special procedures how wills are done. They're generally a formal document. It goes through a legal process. It needs to be signed and witnessed as required by state law. It does get filed in court, and it is a public document. And the court will oversee the execution of and jurisdiction over any disputes. So people need to be aware that a will is not just, okay, I just file it and that's it. There's a court process, and sometimes those processes can take a very long time to get through the system for specific complex situations. Let's say you have an heir that's in a different state or different country, or unknown heirs, or other complications that could be problems of why wills would not be properly executed and not executed properly, processed through the court upon someone's death. So that takes us to trusts. Many of our matters that we do in the office, and we do a lot of them, my partners and myself, our goal is to avoid having a will to be the document that's going to decide how assets are distributed. That's kind of like a document that we have that should be like a catch-all, just in case. So when we, for example, in our office, and I know other attorneys who do similar practices like us, will prepare a trust, will prepare assets to be transferred in a trust document. So it's an incomplete gift. We'll explain that in a few moments. But the documents would transfer so that we don't have to actually use the will. And there's a lot of reasons for why we do that. One is because people are doing Medicaid planning, so we try to structure it so they don't really have probatable assets that go to the court. The other thing we do is we really don't want to go to the court system. We want, people come to lawyers, they pay a lot of money to go to a lawyer to do documents. The last thing they want to do is to have documents that need to be, to go through the court system and spend more money to get a document to go through the system. So
You want to
we
listen
try.
to this too?
I'm sorry. I don't know if anyone has any questions. You can, we'll do it at the end, okay? Or you can put questions in the bottom, and I'll go through them a little bit later. So give me 1 second. Just trying to see if there's. Give me 1 sec. So with respect to so what we've actually had is situations where there are so people ask, then why are you doing a will? What's the purpose of it, right? So we still do it just in case there are assets that are discovered later. For example, we've had situations where someone, believe it or not, actually happened. They had a winning lottery ticket that we found in their house that wasn't claimed, like from 2-3 weeks before they died. That had to be probated, believe it or not, because they actually signed it, believe it or not. If it wasn't signed, somebody else would just take it and move on, but they actually signed the lottery ticket. Other times are if there's personal injury cases, for example, the claims are going to go through the court. So the will, you need to have a will as a catch-all just in case. So what other techniques do we use if it's not going to be through operation of law? Let's say this is real estate or other documents, or you want to have strings attached, you don't want a joint account. We prepare trusts, and a trust is kind of a best example is like a separate corporation or a separate entity. It's a fiduciary relationship between the grantor, who's the person who creates the trust, and the trustees, who are like the managers of the trust. And if there are any assets in the trusts that will dictate how the assets will be distributed upon death. The agreement sets the terms of how the trustee shall manage the assets, distribution of to the designated beneficiaries. And this is what I was mentioning earlier, where someone could put assets in a trust and make sure that if they have a special needs child, they will go to the special needs child will then you don't want to give it to them outright, so you can make a supplemental needs trust within the trust, and it says that this child will not get any money directly to interfere with their government benefits if they're on Medicaid, for example, but will get the money from the trustee at his or her discretion can give supplemental items, clothing, vacation, but so long that it doesn't interfere with the the child's ability to get government benefits. And this is a very routine thing that we do quite often. So unlike wills, which take effect upon death and requires oversight by the court, the trust becomes effective upon the transfer of assets that are put into it. And it's immediately effective, but you can have strings attached. And when we do our trusts, we try to get the best of both worlds. We try to make it in such a way where, for income tax purposes, we look where it's the best place to who should pay the taxes and who gets the benefits, and who should, for example, we've had trusts where the person puts their house in the trust. They still want to live there during their lifetime. So they don't want to be kicked out. So they can have a trust. The house could be put in a trust. Everything stays the same. They still live there. The parents still live there, but the house is in a trust. The only difference is on legal paper. On paper, they have a life estate. They have the right to live there during their lifetime. And upon death, it automatically goes to the beneficiaries under the trust. And you avoid probate. The government can't touch it. You can get Medicaid if you do that. And you don't go through the court system. And finally, during the lifetime, nobody can kick out the parents. It's their house. They have 100% rights to live there. They can't be kicked out. The trustees, whether the children or anyone else, cannot legally do anything to throw them out. In fact, the parents have all the benefits as if they own the house. So if there's any veteran benefits or any benefits as a in New York, the star exemptions or any local exemptions to the property, they will continue to receive those benefits. And the other benefit, which is a very big benefit, is you get a step up in basis. It's still considered, even though it's put in the trust, it is still considered an asset of the grantor for tax purposes, for estate tax purposes. And that's very important. And you'll hear about that in a few moments. That's important because the benefit, if someone bought a property for $50,000 and upon their death it's worth $1 million, in theory, if they sold the house, they would have to pay income tax between the $1 million and the, I don't know, $100,000 they paid for the basis. But if it goes through an incomplete gift through the trust done correctly, it will be an asset for purposes of taxes. It's going to be deemed as their asset. There'll be a step up in basis, and the value of the property, the purchase price for the beneficiaries, say the children, are going to be the ones that are going to ultimately sell the property. They will have their purchase price will be $1 million, let's say. So if they sell it the day after the person passes away, there's a zero tax, and that's a very big tax savings. A lot of accountants don't know this. So we've educated a lot of accountants about these things. Now, what happens if someone doesn't have, as I mentioned, no will? They die intestate, and the law will say by law how the assets will be split. So, as I kind of mentioned briefly, benefits of wills and trusts, what's the difference? Kind of briefly go over some of the items. Wills take effect upon death. Trusts may be used both during the lifetime and after death. Trusts and wills could work together. Trusts are private documents. They are not public record. You cannot go to the courthouse and look at them if they're not filed anywhere. There's no reason for it to be filed unless there's a lawsuit or some other reason, but they're not typically filed. Trusts facilitate the transfer of assets to heirs without costs and time of the probate courts. Trusts do not require consent or notice to parties. So if people want to keep it private, the transfer, it's all a private transaction. Really, no one really knows about it. You don't even have to tell the beneficiaries about it if you don't want to. They'll just find out about it later on. It's confidential. Many people use trusts if they want to ensure privacy for family businesses or real estate. that's not publicly identifiable. So many people have trust for LLCs that they may own, real estate businesses. That's the best place to do it, is through a trust, so you can avoid probate in court. Now, there are different types of trusts. I mentioned trusts. I hope I'm not going too quick here, but there's a lot to cover here. Trusts, there's something called a revocable trust, which means that the trust can be revoked. That's what a revocable means, right? And an irrevocable trust means a trust is designed that it's not supposed to be revoked. I will tell you that if done correctly, an irrevocable trust in certain circumstances could be revoked, and you can reserve yourself various powers so that it's essentially, or has the benefits of being revocable. So people may say, why should I do revocable as opposed to, why should I make something irrevocable if I can do revocable? Because in many circumstances, to qualify for Medicaid, you will need an irrevocable trust. So that's why it's important to know about irrevocable trusts. Now, there's different types of we have different types of trusts out there. There's charitable trusts, there's insurance trusts, there's special needs trusts, which I mentioned earlier for someone has a special needs child, they're on Medicaid or government benefits. There's Medicaid asset protection trusts. There are various different types of trusts, credit shelter trust. I mean, there's all different types of trusts that people create. Trusts for minors, all different type of trusts. Really depends on the circumstances that people have. And I was mentioning to you about the irrevocable trusts. It's a great way to be used to protect people's residences and then their assets. It's really a phenomenal tool, and we do it very often. I think every day we're doing probably 2-3 for various people that I know in our office because it's so popular. It protects the residents, as I mentioned earlier, from potential Medicaid liens or other creditors. It helps avoid probate, and it's great. Now, regarding New Jersey's rules regarding Medicaid, because I keep on mentioning Medicaid and people have an interest about that. We will get to in a moment what Medicaid is exactly and how it fits in, but many people have insurance out there. They think they have health insurance, everything's perfect. They have Medicare. I have health insurance, everything's fine. People do not realize that most health insurance and Medicare does not provide for long-term care. This is a very big concern. People unfortunately learn about this the hard way. So Medicaid is something that people should seriously consider as an option. And when I say Medicaid, I'm going to explain to you what that means. But people think that if they need to go in a nursing home, I have health insurance. That's not going to work. You need a long-term care policy after 100 days in being in a rehab. So people can have health insurance or Medicare. Medicare will only pay for the first 100 days if someone needs to go to a nursing home. So what do you do? So if someone has to go into a nursing home, and nursing home can get very expensive very, very quickly, it's a big problem. So people who are getting older should think about considering being qualified for Medicaid. As I mentioned, you can have your home, live there, put it into a trust, and you'll qualify for Medicaid. There's things you can do so that you can qualify for Medicaid if and when you ever need it without having to buy a long-term care policy. Again, it's not for everyone. If people have, several $1 million, probably wise, if they're already sitting on several $1 million, maybe you have to assess whether it's worth it or not. But, again, typically under $10 million, we're talking about in assets, people could qualify for Medicaid. So how does that work? There is a 5-year look-back period. The government doesn't want you to say, okay, great, you need to go out. Do you have to go to nursing home tomorrow? Great, you can qualify. No, they will look back to see your assets and transfers that you had in the last 5 years. So that's a very serious matter. New York's a little bit more lenient about this in certain areas, but I don't know if most of our crowd is New Jersey, but for those who have people in New York also has a 5-year look back period. But for home care, New York gives you a essentially right now it's a zero look back period. So people who need home care and aid could essentially transfer all their assets today and get an aid tomorrow. That's changing in New York very, very soon. But in New Jersey, there's a 5-year look back period. So people really need to think about if they're starting to get health is declining, or the doctor starts saying that you need to be concerned about where you're going to be in, a number of years. It's very important to move quickly to do an appropriate estate plan and potentially consider Medicaid planning, because there's a 5-year look back period. And some of the rules in New Jersey are very strict. You can only have $3,000 in assets. It's a very low number. New York is, for example, $30,000. And IRAs in New Jersey are not exempt. That means that if someone can have, a few $1,000,000 in IRAs in New Jersey, they are not exempt. You have to spend them down or do some appropriate planning. And that's a very serious thing if someone wants to consider Medicaid, unlike in New York where IRAs are exempt. So that's a very, in New Jersey, we find it a lot more, stricter about it. So it's $3,000. People are asking questions, $3,000 per person. And people asking about spousal refusal laws. Spousal refusal is not gonna prevent you from, is not gonna work, because spousal refusal means that the government is gonna come after the spouse for the assets. So that's why it's important to do the appropriate planning years, New York, and it's not going to be available in New Jersey. Now, tax planning is another area that people need to consider. Currently, under federal law, you can have about $12.92 million in exemption from estate and gift tax per year per person. So estate and gift tax per person, I'm sorry. Now, that means that when I was giving you an example about the step up in basis, you get a step up in basis and there's no tax on that. So the purpose of the step up in basis initially was so that the government could tax you on the fair market value of the property. So if someone bought a property for $100,000 and then it's worth $6 million, or stocks and bonds and everything, if it's put in a trust for purposes of estate taxes, it is considered, let's just say it's 100, all the assets are $500,000 over the years. And if they were to sell it today, they would get $6 million. So you'd have to pay income tax between the $6 million and $500,000, because $500,000 is your basis for all your assets, let's just say. But if you put in a trust, then the basis jumps up to the value of death. So if the children decide to sell these assets very soon after death, the basis is going to be zero. It's going to be a zero tax. Obviously, if the children, keep the assets for longer, so let's say it's $6 million upon death, but then it goes up to $12 million when they sell it, the purchase price for the children's purposes is that $6 million. Now, the good news is there's no estate tax, because the federal exemption is for the first $13 million, we won't tax you on your assets. So you get the step up in basis, it jumps up in value, but there's no tax. Now, this law that's in effect currently in federal law expires December 31st, 2025. It may get extended, it may be adjusted. These tax laws always, all the time, every time this happens, we don't know what is going to happen exactly. But if nothing gets changed, then it automatically reverts back to $6 million exemption. Now, New York has an estate tax exclusion of roughly $6.5 million in 2023. So it's really a little bit 6.9. But that means that, for our clients in New York, we're watching, we're not looking at the $12 million threshold. We're looking at the $6 to $7 million threshold, because if they pass away, they're going to have to pay taxes once they hit the $6.8 million. Florida, for example, has no estate tax at all. And New Jersey has no estate tax, but does have an inheritance tax, which is a tax that is in effect if the asset goes to someone who is not a descendant of the decedent. In other words, they won't have any inheritance tax if it goes to a child, for example. But if someone says, I'm giving, $1 million to my friend, that friend will be subject to a small, but there is something called an inheritance tax. Now, this is what I was mentioning earlier regarding the step up in basis. I kind of mentioned this already. But one thing I wanted to mention is that transferring to the trust or children for Medicaid planning while maintaining your assets as part of your taxable estate is an important way to use the trusts. And that's why we recommend people to use trusts. So I'm going to jump now back to, that was kind of like the overview on trusts and, the wills. In the beginning, I mentioned to you about the healthcare proxy, healthcare directive. So I'm going to jump now to other documents that people should kind of have in place and consider those items. And that would be the advanced directives. As I mentioned earlier, Chaim Aruchim form or other healthcare proxies or proxy directives are called an advanced directive. What's an advanced directive? It's a document that you can prepare while you're alive and well and give instructions for if, God forbid, a crisis happens down the line or certain situations happen down the line. So one document is known as a power of attorney, and that's a document that's used typically for financial arrangements. So if someone has assets and they say, I have a power of attorney, you can give instructions to your agents under the power of attorney what to do if you need it down the line, if you want assets to be transferred, someone is not capable of doing it. So for example, many times as part of what our package is of when we do estate planning in our office, we'll have power of attorneys prepared as well, because in case someone becomes incapacitated, then the agent could do transfers of assets and do other things, maybe even do Medicaid planning at that point, emergency Medicaid planning, or giving instructions at that point in time. And healthcare proxies I mentioned earlier, those are documents that many hospitals insist that, or try to get people to sign off to do it before major surgery in case something goes wrong and they want to know who to speak to. Who should be the one in charge should there be an issue during the surgeries or after. There's living wills, which are instructions what to do with, let's say, DNRs, do not resuscitate, or other type of orders. I will tell you that the halachic version of this, which is in the Chaim Aruchim website, it's a combination of a healthcare proxy and a living will. So if you look at that one, which I'm not going to pull out right now generally, but generally they have, for those who want to use that form, it will say, I would like you to consult a certain rabbi, for example. So they'll give instructions, let's say it be one daughter, to be the one who's the agent under the healthcare proxy, but that daughter is instructed to call a certain rabbi to make certain healthcare decisions. And that could be, again, these are legally binding documents, and they're very important to have. And it gives a peace of mind to know that you're making this decision well in advance of ever having the need to do this, not rushed, or you don't want to leave it to just kind of let it figure out whoever, happens to figure this stuff out. Burial instructions is another one that it's also, again, not very common that people do it, but I've seen it prepared when people have different religious beliefs as to how they want their remains to be disposed of. So you can have, if you have children, I've seen this happen where someone has one child that wants cremation, another one wants to follow Orthodox Jewish burial, and the parents are worried that the child who's going to want cremation is going to push him or herself and push it their way through. So they make these burial instructions as well to make sure that it's done correctly. I've even seen crazy stuff, like, I could, believe it or not, I've seen this happen where someone had a lot of kids, And some kids wanted, I remember this was after the father passed away, and the mother did not want to be buried near the spouse. And some children says you have to be buried near the spouse. So there was some children said be buried next to the spouse. I don't care what you say. She had instructions, very specific instructions, for whatever personal reason she had. She did not want to be buried near her husband. So she said, here are my burial instructions. They're legally binding documents, obviously done when she's still alive, and those instructions have to be honored. Of course, I've seen situations where people, gets in the wrong hands and kind of disappears, but assuming that it's done correctly and it's the right person holds those documents, then it's done the right way. Now, what happens if someone doesn't have advance directives? They may have to go through a very costly court process known as a guardianship, or in certain states called conservatorship. In New Jersey, it's called a guardianship as well. They could, a lot of court involvement. It can take a long time. It's a costly process and a lot of intervention with different people involved. So all that can be pretty much avoided in most circumstances if appropriate planning is done. Not in every case. There are situations, even with advance directives, and we'll get to that in a few moments, where you may still need to have a guardianship. I mentioned what a power of attorney is before. A living will, as I was mentioning before, can override the instructions of an agent you appoint. So you can give instructions. So if you have a healthcare proxy that says, I'm appointing so-and-so to make healthcare decisions, a living will could supersede that instruction. For example, someone has DNR, or they want to be organ donors or not be an organ donor. I mean, all that could be put into the documents. But there are some states now, Nevada being one of them, which has an automatic opt-in that people are automatic organ donors. So if you want to avoid that, again, we're not in Nevada, but I'm mentioning that people should be aware of this. For example, in Nevada, people are all making sure they have these living wills saying if they don't want their organs to be donated, they go in and make sure that they have a living will. I don't know if this law is going to change in other states, but people should have a living will if it's not already incorporated in their healthcare proxy, if they feel that they're concerned that this could be an issue in their specific circumstance. So about advance directives, there are a little chart here about different types of advance directives. A DNR, which is a hospital notice that the doctors can do, is called do not resuscitate or do not intubate, is another one. New York has the Family Healthcare Decisions Act. Don't believe New Jersey is part of that. They're working on getting all the states to be part of this uniform, act. Healthcare proxies. I mean, this is this is just the rules on it. This is actually the New York rule I have here. One important thing is also important for the healthcare proxy. It should include a provision for HIPAA release of medical records, which is very important, especially if someone wants a child to or someone else to make the decisions. One thing that we had, I believe, at the last year's, we gave a seminar last year. I'm trying to remember where it was, whether it was in somewhere in Lakewood or at the Agudas Yisrael of America convention. I think I may have mentioned it in both places. Some issues have come up where people say, in New York, it was like under the Healthcare Family Act, there's an order, even if you don't have a healthcare proxy. Spouse being the first, after a spouse, essentially the children go next. So if someone says, I have a spouse, the hospitals are always listen to the spouse first. We'll do that. What do I need to do a healthcare proxy? Let my spouse make those decisions. And I get it. If there's 2 children or more than 2 children, that's going to cause confusion in the hospital. But I gave you an example earlier that's a very good example where there could be confusion with the mother with 2 daughters. But I've seen many people recommend, I think Chaim Ruchum's rabbis had recommended that it not be a spouse to make those decisions for healthcare proxy. In most circumstances, people are elderly. This is a little bit too much over their head. If God forbid their spouse is ill in the hospital, they're under a lot of stress, and making the spouse being responsible could be a lot of complications, both for that spouse and the stress that that spouse is going to have to go through, and the pressure that the different children, for example, may give that spouse on how to make a decision. So many circumstances we're telling people it's great you can have your spouse, but don't make the spouse the legally, the legal person to make that decision. Otherwise, what's going to happen is that spouse could be under tremendous stress. And to avoid that, you pick the one who's the most responsible child for this issue. So, for example, I worked on a matter where someone did not trust his son. He has two sons. One son is one of the top doctors in New York, but also someone you would not trust to handle any of the financials. The other son was running the family business. So what dad did over there was he's giving everything equally. All his assets split 50-50, even though one son is a doctor and the other son is going to take over the business. But when it came to health, so he had two sets of documents. Everything financial related was to the son who he can trust, who ran the business. And healthcare proxy goes to the other son who is, a big surgeon, big doctor. And we had to have, there was a guardianship involved over there as well, for other reasons, a little bit complicated for, beyond the scope of today's seminar. But the judge was laughing and saying, I only know two people in the world that have a doctor on call, the president of the United States and this guy, because this guy really had a top doctor who really knew what to do, and he trusted him. Again, COVID shot, not COVID shot, this is all pre that, but he didn't want to trust the other son who didn't know, the medical care as much. So he trusted that person. So you can have different documents for different, people. Here's, I guess I have to hear the rule about the living will, New York rule. Getting to the guardianship, again, I'm trying to be, move along because we don't have that much time left, but when is a guardianship needed? If the advance directives are done when the person is capable of executing such documents. So if there are no advance directives and there's an issue that comes up that cannot be resolved, then you'll need a guardianship. Or if there's a defective or missing advance directive. Examples of no advance directive is someone needs to get access to the bank accounts, but the person had a stroke and cannot handle the affairs. They have no power of attorney, and the bank says, I'm not talking to you. So you may have to go to a court and do that. A missing advance directive is, let's say there's no gifting powers in the power of attorney, but you need that if you want to do an appropriate planning of some sort of Medicaid planning. So you go to a judge to kind of fill that gap. Or if there's a need to expand the powers beyond the existing advance directives. These are examples of when a guardianship is needed. And here's a nice little handy chart here about New Jersey that I put together. The common guardianships, and there's different types of guardianships and protective arrangements that is available in New Jersey. If anyone needs, these charts, you can definitely feel free to email me, by the way. And I'll put it on the chat, my email address, if anyone wants this information. So I put that on for everyone if they want to be able to email me, and I can, get you a set of our documents here today. And so that's pretty much my summary of this. Does anyone have any questions on these topics? Feel free to, either, I guess, put it in the chat, or I think you can raise your hand on this somehow. Or for you, I guess you can speak if you want to unmute yourself. I don't know how you want to do this.
I have a question.
Sure.
I advise people as a social worker, worked in.
Hold on, let me just, I'm sorry, I can't hear you so well. Can you speak up a little louder?
Sure. I'm a social worker, so I advise people in geriatrics. And my question is this. Very often people have a decline in their health and they need to go into a rehab. And they go into a rehab and it pays, as you mentioned, if you qualify for the 100 days, either Medicare or your insurance, because you can end up getting less. But when you talk to people and ask them, what are you going to do if, God forbid, you don't get better? They say, I'm going to get better. And that, that's their plan. And you push them, you say, you need to plan and think about, what if you don't get better? Here in New Jersey, as you mentioned, you do not get that much home care. So what happens is they're in the facility, they're doing rehab, working very hard, and then they are no longer, Medicare, their insurance is no longer going to pay for their care because they've reached their highest potential. So now they're stuck. And so we talk about Medicaid planning, and they say, and you explain it to them, and they explain to you, well, I gave away, this amount of money and this amount, a lot of money. And you look into it and they're not eligible. So now you're stuck because they can't go home, but yet they can't stay in the facility. So what happens is they stay in the facility and are not paying. And so I wanted to know if there's anything that can be legally done in a case like that, or do they just end up staying inside a facility for as long as they need to and not pay?
Not good.
Interesting question. I think there was a few questions there. But basically, first of all, that's why we recommend appropriate planning in advance as possible. And one of the things that we tell people is, when your first question that you mentioned earlier is like, well, why do I need to do it? I'll be fine. Why do you get life insurance, or why do you get car insurance? I mean, or, property insurance. You get it because you don't want your house burning down. You don't want things to happen. But you have to prepare for the possibility if something does happen. And what are you going to do at that point? That's number one. But with respect to the other part that you were mentioning, it's going to be a problem if they're in a facility and they don't pay. The facility is going to cause problems. They're going to find assets. I've dealt with these issues. They will sue family members if they have to get assets that may have been transferred. They will come up with creative ways to push the person out of the facility. They're not in the business of doing this for free. So they're going to be serious problems if they just say, I'm going to sit here and do nothing. In fact, some facilities will my office does it. We bring guardianships many times. If a person doesn't leave the facility, we'll bring a guardianship to have
How can you bring a guardianship if someone is still competent?
If they're still competent, there are times where the definition of competency is not clear cut as you think it is. Competent could mean that person can walk and talk, but if they're not handling their own affairs correctly, then a facility could still bring a guardianship saying, yes, the person has mental capacity, but they're not capable of handling their financial affairs. So if someone is wheelchair bound, for example, and not able to go to the bank and handle their affairs, we can bring a guardianship for a person like that. That person, someone needs to go in and handle their financial affairs, or the family isn't cooperating and doing what they're supposed to do to qualify the person for Medicaid or do other things. So it's very important that that be done. But I will tell you, what your specific circumstances is talking about a situation where what I'll call emergency Medicaid planning. And there are certain techniques that could be done at that point in time. And again, it's very specific. There are certain things you will not save all the assets. There's something called promissory note planning, or the rule of halves. I mean, this is all complicated procedures and rules that lawyers will do, and it will cost you more money doing it then, because you're going to lose half the assets at that point in time. So that's why we tell people, try to do this as early as possible, not crazy early, not when you're like 20 years old, unless something's going to happen. You do it as with the anticipation when people, there's a doctor that I spoke with him at some seminars, and what he keeps on saying is, and he's a neurologist, he says, if you're age 60 and you don't have a trust, you're crazy. Like, that's his rule. You hit age 60, you got to do it. because at that point you should be already hitting retirement. You should be at a point where you're getting close to this 5-year look back period, where there could be people who could start getting, more illnesses at age 65 or 70. So, there are people who go till 90 and start to do it at that point in time. They're lucky they didn't have any issues till then, but it's something that people should seriously consider. So there are techniques that could be done, even if someone's in a facility, but typically you end up losing half the assets. And that's not a smart thing to be dealing with.
I have to disagree with you just on one point. I speak to people about it on the first day, and I speak to them on the second day and on the third day. Many, many people say, I'm going to get better and I will not discuss it and I will not do anything. So I'm just telling you, it's a big
Oh, I
problem.
know. I agree with you. I'm not I'm
try.
not disagreeing with you that doesn't happen. I'm saying
And I
that,
explained to them why, and it just doesn't go. Many people.
so I will tell you, you are right. We have cases like that. And unfortunately, I will tell you that those are the cases that end up being guardianships in our office many times. I've had that happen. I had someone who had a nice big estate, $40 million estate, New Jersey residents, $40 million estate. They insisted not doing anything. Everything's perfect. Don't have to do anything. I'm not going to do it. Exactly what you said. They didn't do anything. They ended up being, going into, becoming incapacitated. The son owns nursing homes, and he knew exactly what to do. He called our office and says, we're filing a guardianship immediately, which we did. And we were able to, within a very short window, move the assets and protect it. And that case was actually more for estate tax purposes. And we were able to move everything. I will tell you, we moved all the assets 12 hours before the person died. Happens to be, they lucked out in that situation. So that's what happened. There's a lot of, I'm seeing some notes here about spending down until, there are ways to spend down assets. We're trying to avoid having you to spend down the assets if you could do appropriate planning in advance. If you prepare when you're healthy, you don't have to just spend down all your assets. Protect them, save them for your hard-earned assets to the people you wanted to ultimately have them. So that's what I would do. Now, people fear Medicaid. So yes, it is true. People think Medicaid is only for the poor. It's designed for the poor, but I will tell you that in most nursing homes, the people who are on Medicaid are middle-class people who were hardworking over all, their entire lifetime, but they just didn't, they're just below, they have the typical person who is on Medicaid that come to our office probably owns one, residential property where they live, a vacation home, maybe two more investment properties, and stocks and bonds. This is the typical middle-class person that comes in and they don't want to lose their assets. So people very often think that Medicaid, it's only for poor people. And it's designed for that, but it's also designed for the middle class, because if they don't do anything, by the way, and they do end up in this situation where some nursing homes are really expensive. If someone's on a vent, that's like $1,500 a day. So, assuming they don't even have a vent unit, $1,000 a day, with kidney and vent, it could be very expensive. Some people are paying $300,000 a year on nursing home care. I mean, that's a lot of money for people who, made $50,000 a year during their lifetime. That's 6 years worth of salary. So, it can get blown very quickly in 1 year. So that's how that works. People talk about if they're over the monthly income amount. So there's something called pooled income trusts, which you can transfer. This again, you speak to your lawyer who's going to handle this. You can transfer the assets in something called the pooled income trusts, so that the monies that are above the allowed amount can go into a pooled income trust. That's what it is, a special type of trust which allows you to kind of still continue yourself to be on Medicaid. Now, someone mentions our packages. I don't see them on your website. Can you give us an idea what your packages are? Well, so what I say is packages is kind of like when a typical person comes in to our office, for example, for estate planning, it's case by case. So we do an assessment of what the person needs. Like we'll have an educational seminar. We tell someone, bring in all your information, your family information, your assets information, how they're listed. We kind of sit down and try to figure out what's best for the particular person. And we will many times we will put we'll tell you you may need a trust, you may need some deeds. When I say is we typically want to make sure that if someone is going to have any estate plan, we want to make sure that they have a trust if that's what's appropriate for them. Not everyone needs a trust, but we need a trust and any deed transfers that go with that. A will. Remember, I mentioned I want to do a catch-all to cover just in case there's assets that we didn't catch in time. A healthcare proxy, which I mentioned why you need that. A power of attorney, mentioned that. For those who want to really make sure, and they're Orthodox Jews, we also give them a halachic will on top of the other documents to kind of, again, that's for very specific circumstances, for those who want to make sure that they follow Orthodox law, but more importantly, they want to make sure that there's no fights after they pass away. So the reason for that is because someone may have one son, 3 daughters, and wants to, let's say, split everything equally amongst the children. If they do this with a halachic document, it will be split evenly. If they don't do a halachic document, you'll have the daughter saying, here's the will and I want to follow the will, and the son says everything comes to me under halacha. So you really need to know that's under, the Jewish law to avoid that problem. And I'm not saying people should be religious, not religious. We have the non-Jewish lawyers in our office preparing these documents too. We do it so that we don't have a problem for our clients. That's what we're looking out for. So I don't care what sect our client is. I don't care which, religious, whether it's modern Orthodox or Hasidic. We don't care. We just want the document to work in any rabbinical court and in every court so that they don't run into that problem. So we're going to follow the rules, to the T on that. And we will ask our clients to speak to their rabbis to make sure that that document is right. We'll put that in there as well for our clients when they need it. Now, someone asks about how much these costs are. It's really, it depends. I mean, this is, it's case by case. I know there are a few $1,000s. I don't know the exact dollar amount of what they are. I actually, don't deal with that in our office specifically. I know I've done trusts anywhere from $4,000 to $8,000. Usually the average maybe $5,000, $6,000, $4,500, depends on what it is, depending how complicated it is. When someone has no assets, they don't need a trust, So when someone has a lot of assets, they can have these very complicated estates where we had to do 25 deeds. So that's expensive and it's a lot of time. So we do that. Now, someone asks, how do you recommend protecting IRAs? Should we not build up our IRA accounts as we age? You should. Again, this is a loaded question. IRAs has tremendous benefits, but there are ways to structure this so that the assets are protected. So you do want to build it up. And again, the 5-year look back period is a time where you can start figuring out the best way to structure this so that you get the benefits for the taxes and deal with the IRAs. But many times the IRAs must be spent down. So again, IRAs are tax deferred. So many times people will say, they'll make a certain amount of income when they're, when they're younger, and then when they're retired or they stop working at age 65, well, they have no income. So then they start pulling money out of the IRA and then pay taxes on that. So kind of spreading out the benefit of the tax deferral or tax benefits. Now, someone asked about what the 5-year look back period entails. When someone goes on Medicaid, because they know that Medicaid is expensive and healthcare is expensive, it's through federal law. And every state could jump on it, which most states have said 5 years. That means that if someone transfers their assets today, there's a risk if they end up in a nursing home between now and in 5 years from now, Medicaid will say, you know, I see you have $3,000 in the bank or $1,000 in the bank. Let me see your bank accounts for the last 5 years. Let me make sure that it was pretty much consistent like that all along. Now, it's beyond the scope of today's session, but you could have circumstances where people were gifting throughout the years, and you can go to a hearing and say, listen, I always gave $20,000 a year in gifts. I can show going back for 30 years I did that. So if you continue doing that within the 5 years, you could fight them at a hearing and do that. Our recommendation is to avoid that. Why spend more money on legal fees or take a risk? So the recommendation is, again, if you could, if someone realizes, we've seen this where people started, you know, unfortunately, doctors tell them that they're starting to show early signs of dementia, they better jump on this quickly, and they do it. If 5 years go by and they don't have an issue, 5 year and 1 day, they're scot-free, they're on Medicaid, they qualify, everything's great. The point is they look back 5 years. So that's important to understand that concept happens, and that's why, you know, it's great to be able to kind of predict the future. You know, we've had people, one scary time we had someone came into our office, we did estate planning, did everything great. My partner did this one, went to the guy's house, did the will, did the trust. And this is another example why, you know, will, and I don't want to be pessimistic, but this is what happened in that case. I gave you the example of the lottery ticket where someone won a lot of money, but here's an example where someone does a will, does a trust, does everything, and then an hour later he happened to have passed away, had a heart attack. So we had no choice but to rely on what the will said. That was literally done an hour before he passed away. So that's important to do that. A question about UK citizen and alien US resident. Will my will be trust be governed by UK US law? So I'm not an international guy, so I don't know the exact rules, but you definitely, I would have to ask my partner. But if you're a resident, if you're a US resident and you have assets in the United States, you definitely should have a will in the United States. We even tell people who have assets in Israel and they're US residents to make sure they have a will in Israel as well, because if they have assets in Israel, not because the will won't be recognized. The will be recognized, a US will. The problem is the complexity on getting that will done in Israel, probate in Israel could be a problem. And we tell people to have an Israeli will as well. So someone mentioned that all deposits withdrawals of $2,000 plus are scrutinized. Yes, that is true. They look at everything. These Medicaid applications is, you know, especially for those who didn't do the 5 year, you know, look back period, and some assets are at risk, they will look at every transaction. Got to save receipts. Again, medical expenses, you're allowed to have expenses, you know, during your lifetime. If you can show they were used for yourself, that's okay. So people don't, and I want to clarify that. It doesn't mean you can't have anything. It just means that during the 5 years, all the money in the account should primarily be used for you. So if you go on vacation every year and you go on an expensive vacation, you know, you spend, let's say you have a budget of $30,000 a year vacation.
I'm sorry, I mailed it out.
So you can do that.
For Ellie,
If you have
348 Main Avenue.
if you have either you know, your utility bills, your expenses, that's okay. That's not, the Medicaid is looking, just when I say the 5 year look back period,
A lawyer
Medicaid is
talking
looking
about
for
estate, Medicaid.
transfers of assets to other family members to not qualify for Medicaid. That's what they're looking for. I'm sorry, to someone,
let me shut
they
this
can mute
off.
themselves because
Someone needs to be muted.
He's off. I don't know. He had some,
if you can,
They
Ms. Katz, if
called
you can
me.
mute
If
that
everyone
one
could
person.
mute.
Rita, please mute yourself. Whoever's Rita, mute yourself.
So what I was saying is the 5 year look back period is looking to see what they're scrutinizing what you did for the last 5 years. That's really what it comes down to. They want to see if you transferred assets in those 5 years so that you can qualify for Medicaid. That's what they're looking for. So if you spent money on yourself in the 5 years, there's nothing wrong with that. If you gave gifts every year, so let's say someone had $1 million. They said, you know, if they see that 4 years ago you transferred $1 million to your kids, that's a problem. And that's the 5-year look back period, and you won't qualify for Medicaid because you did these transfers during those 5 years. If you spent it for other things, that's okay. So it's okay to spend, as I mentioned before, you know, household expenses, rent, mortgages, anything related to you. The only thing is they're going to scrutinize everything. They're going to want to see, I see you had a $2,000 withdrawal. What did you do with it? Well, I paid my handyman for that, whatever. They want to see what you did. So they're going to scrutinize your transactions for the last 5 years. We have had situations we tell people that they did planning and it was 4 years ago, or 4.5 years ago. We'll tell them, don't go on Medicaid for 5 months or 6 months, whatever the period of time is, so they could avoid being on Medicaid. You know, you don't want them to have these records going to Medicaid, and they're going to disqualify them for Medicaid. So you say, don't go on Medicaid for the next 5 months. So you hit the 5 years, and then then apply for Medicaid, and then Medicaid is going to say, okay, let me see the transactions for the last 5 years. None of those transfers are going to be there because it happened 5 years ago. Now, these rules over the years have been getting worse and worse, naturally, for natural reasons, because the government sees that people were doing transfers of assets to protect for Medicaid. Now, a few years ago, it used to be a 3-year look back period, and it used to be the penalty period started from when you transferred. That's not the case today. Today, if someone did a transfer 4 years ago and 11 months, and they see it, you're just disqualified for Medicaid for the next 5 years, which is a problem. So what you do is it used to be a 3-year look back period. And if the 3-year look back period meant, you know, that it was $100,000 that was transferred, and the penalty period, there's a certain formula that comes in there. They may have finished it up in 1 year, so they're qualified for Medicaid now. They don't do that anymore. It's the rule is 5 years from now when the person applies for Medicaid. So that's how they do that.
Thank you so much. It looks like we are out of our time, but this was, I think you got in many of the questions in the chat.
Okay, so I thank everyone for listening tonight. I hope it's been informative, and you have my email address if you have any questions, or if people want, that's the best way to reach us if you have any questions. If you want to do a consult with our office, you can call our office, and our number for that is 212-495-8133. And I guess there's no other questions. So good luck, everyone, with everything.
Thank you very much.
You're welcome. Take care. Bye.
Thank you.
Thank you, everyone, for joining.
Thank you. Bye.